So while more people join, let me welcome you again to this webinar on the state of play assessment on statelessness in Europe. And my name is Patricia Cabral. I'm the legal policy coordinator at the European Network on Statelessness. And it really is a pleasure to welcome you to this webinar. For those of you who are not familiar with ENS, we are a civil society alliance of over 180 organizations and individual experts working to address statelessness in 41 European countries through law and policy development, awareness raising, and capacity building. So today we're very excited to see that we've had over 200 people registered to participate, and people are joining as the morning starts as well. So please do say hello in the chat, and if you like, tell us your name, your organization, the country where you work, or where you're joining us from today. The result of the polls will also be shared soon with all participants, but I'm sure that what we can see is quite a mix of people that have come across with the index before, but also have not seen it yet. And so I will be presenting a bit of an introduction to the index, but also really highlighting the work of our members, many of whom are here today as well. What we are doing today is launching the full update of our Statelessness Index, which is one of the key resources that we have on statelessness across Europe, but there are also other resources available in our website. We will also have a forthcoming pan-regional conference on addressing statelessness in Europe, which will take place in Madrid on the 8th and 9th of June, and colleagues will shortly be posting links to register for the conference on the chat. And if you are interested in learning more about statelessness and staying engaged with your work, please do stay in touch. Email me after this webinar, or join us in Madrid if you can, or join us in many of the other webinars that we will also be hosting soon. There will be a recording of the session available that will also be made public after the webinar. And then finally, I also just want to say that we will not have a dedicated space for questions and answers today, but we do have Alexia Tizano, who's our legal officer, on the chat, and she will be looking at all of the questions that may be coming in, trying to answer them, and also our panelists will keep an eye on that in case they can help. And if you have any questions that we can't address in the chat today, do email us again, and we'll be able to stay in touch. If you have technical issues, we also have colleagues from ENS that may be able to help. So please message Charlotte in case you have any issues, and she'll try to assist you with that. So the aim of today's webinar is really to present the key trends and data that is emerging from the Statelessness Index, particularly with a focus in the last 2 years, and to identify key areas for action, but also solutions on how to go forwards. So after my initial presentation of our state of play analysis, we'll also have a fantastic panel of 3 country experts who will offer their reflections on what gaps and opportunities there are in Ireland, Germany, and Belgium to improve the situation of stateless people. And we will also hear from our director, Chris Nash, at the end of the webinar. So before we start reflecting on recent changes and trends, let me give you a quick overview of the index. It is an online comparative tool that assesses how countries perform in Europe against international norms and good practices, and it examines how they protect stateless people on their territory and what they are doing to prevent and reduce statelessness as well. We launched the index in 2018, and so far we have 30 countries. And this is really a tool that gives stakeholders an easy way to understand the differences in law and policy between countries, to identify good practices and areas that need to be improved. 5 years on, we have over 43,000 users, and the index has really become an important tool to raise awareness on statelessness, but also to provide a much needed evidence basis for our advocacy and statelessness and to improve protection in Europe. We work with our index country partners in all of the index countries who review and update the detailed country services and analysis. And in doing this, they check for updated statistics, amendments to law and policy, emerging trends from practice from the authorities as well, but also government commitments. And then we review all of that information against our benchmarks. It is an enormous team effort, often with several experts involved in each country, also with several members of the ENS Secretariat. And so I really, really want to deeply thank all of our country partners and all of the ENS team who play an essential role in providing an accurate and up-to-date information that allows the index to be a live tool for monitoring progress. So a big virtual applause to all of you. You can find out more details on the index website about our methodology, also how to use the index. For example, you can access country profiles, but you can also have a comparative tool that allows you to see how different countries score in the same topic. And there are also, for example, thematic briefings available on birth registration, statelessness discrimination procedures, and deprivation of nationality, which provide an overview with more detailed analysis of these particular topics. So do have a look at our website for more information on how to use it and the methodology, and keep looking at it as we keep adding more features and resources, and also keep updating the data. It is to be used as a tool for impactful change. And so the Statelessness Index also allows us to support governments and key stakeholders in identifying those gaps. And for that, we have also launched 3 new country profiles this year. We have last year, apologies, Sweden, Montenegro, and Romania. And we have now just updated all of the information so that you have the most recent data available to you. So reflecting a bit now on the changes that we have seen over the last 2 years, what I was hoping for is that I could present you a clear conclusion on how much progress has been made to address differences in Europe. So I was looking for something like this. But instead, I found that it was quite difficult to find measurable ways to present these developments. And that is because what we see is rather a mixed picture across Europe, something that looks more like this. There have been several steps forward in the last few years. For example, Ukraine has started its implementation of the stateless determination procedure, which was operationalized in 2021. There are also several states that are doing legal reforms or having political discussions to introduce stateless determination procedures. Austria has just last year amended its citizenship law to allow people born on the territory to apply for nationality until they are 21, instead of the previous requirement of 20, which aligns their provision with the 1961 convention. And for example, the Spanish courts have also led the way in providing good examples to prevent childhood statelessness for children who are born in transit to Europe and who would not otherwise be able to have a birth certificate or acquire nationality. But at the same time, there are still clear protection gaps and rights violations that remain to be addressed. Sometimes states have made legal reforms to address statelessness, but then they fall short of international standards when it comes to the details or their implementation. And this means that the real impact is not what we hoped for, and that we have not seen significant improvements in the situation of stateless people in Europe over the last years. Of the 5 thematic areas covered in the index, the most positive assessments are certainly found in the theme that assesses whether countries have acceded to the relevant human rights treaties and core statelessness conventions. This is because most countries do have obligations to protect stateless people and uphold the right to a nationality, but yet far too many states have not yet taken action to fully address those obligations. And this is where the index really is a valuable tool, as it also sets out a roadmap that states can use to address statelessness. There are 4 key areas that I want to highlight today. And the first one being the statelessness determination and status of stateless people in Europe. So only 11 of the 30 index countries have statelessness determination procedures in place to determine who is stateless on the territory, but also to grant them the rights protection that they are due under the 1954 Convention, which is by now almost as old as the Refugee Convention, but far less implemented across the globe. Belgium has, for example, a procedure to determine statelessness, but recognition as a stateless person does not automatically lead to a residence permit, and we will hear more from that as well soon from Valérie. Other countries have only limited ways of identifying who is stateless, if any. And this is simply not good enough, as it leaves thousands of people in limbo, facing immense hurdles to accessing even the most basic rights that we all take for granted. On a positive side, it has been good to see that there is some political willingness to change this. There are ongoing discussions to introduce stateless determination procedures, for example, in Switzerland, in Malta, and in Portugal, and we're remaining in close collaboration with partners on these countries to make sure that these procedures implement the best international standards. Albania has also introduced a statelessness determination procedure in 2021, although we are still awaiting a government instruction that is needed to operationalize this procedure. Ukraine has made its procedure operational in May 2021, but of course, due to the challenges in the war at the moment, it is also difficult to have a fair picture of its implementation, although we already know that the procedure itself has several positive features, but at the same time, there have been some obstacles in its implementation. For example, because applicants are required to contact the foreign consulates themselves, or there are instances of verbal rejections when applicants do not provide adequate documentation. And there are also barriers in obtaining a residence permit when a deportation decision was previously issued due to irregular stay. So overall, good progress, but at the same time, we're conscious of some of these challenges and we want to remain vigilant on this. In the Netherlands, the long discussed legal reforms on statelessness were finally adopted by the House of Representatives in 2022, and they are currently before the Senate. This is a very positive reform that would establish a judicial procedure to determine statelessness, but it also has its own gaps, as, for example, the current proposal does not lead to residence rights. There are also upcoming law reforms in Belgium and Germany that could be an opportunity to address existing gaps, but I will leave that for Dennis and Valerie to talk about in a moment. Although I do not have time to go into too much detail, I also just want to mention that this year the index presents a new analysis of the temporary protection that is being granted to stateless people fleeing the war in Ukraine, which assesses how EU member states have been implementing the EU Temporary Protection Directive and how other countries that are not EU member states have been implementing similar forms of protection. Second area I want to highlight is prevention of statelessness, and in particular childhood statelessness. Almost half of European countries still permit children to be born stateless on their territory, which is really alarming, as we know by far the impact of growing up without a nationality. On a positive note, we have seen Spain leading the way in providing good examples of good practice in preventing childhood statelessness last year. There were two groundbreaking judgments, one of them that recognized for the first time Spanish nationality for a child born on a boat in transit to Spain, because otherwise the child would be stateless, and then another judgment that also ordered the authorities to register the birth of the child who was born in transit to Europe. And this is because the birth certificate was considered essential for the child's legal identity and to acquire a nationality. So these really are important steps to celebrate, and we're encouraging other countries to follow them. However, there are still other steps that are required across Europe. For example, Switzerland, Romania, and Cyprus have no safeguard at all for stateless children born on the territory to acquire a nationality. And then the index shows that even where states do have safeguards in place, they are not always implemented as intended, either because existing safeguards appear not to be applied by the authorities, for example, in Malta and in Croatia, or because safeguards that should be automatic actually require children to prove their statelessness. Several countries also have only partial safeguards, and they pose, for example, residence requirements or are dependent on the residence status of the parents. On a small improvement, we have seen that Austria amended its law last year to allow people born in Austria who would otherwise be stateless to apply for nationality over a 3-year period until they are 21. But this is still not an automatic provision, and there are other barriers that remain. And in fact, we have seen the impact of the lack of full safeguards in Austria in recent studies, which have shown that although Austria previously was mostly a country where statelessness occurred in a migratory context, today there's 70% of people who are registered as stateless or with undetermined nationality in Austria who were actually born there. So this is indeed concerning, and it also is also a reflection of numerous barriers to birth registration that we see across Europe in the majority of index countries, along with a systemic lack of mechanisms to determine a child's nationality status, and overall the lack of full safeguards to prevent statelessness. The new index data also confirms that children of LGBTIQ+ families from across Europe are facing challenges in having their births registered with the names of both parents, which may impact their ability to acquire identity documents and to access nationality. And we have examples from this in Albania, in Montenegro, Bulgaria, Poland. There's also been a few judgments from the European Court of Justice on this. So do have a look at the index for more information that is available now. Finally, we cannot leave this webinar without talking about reduction, as this is the only way to ultimately resolve a person's statelessness and for them to acquire nationality. So this is why the 1954 Convention requires states to facilitate naturalization for stateless people on their territory. And positively, in Ukraine, the residence period required for a stateless person to apply for naturalization was reduced from 5 to 3 years, but the index shows that the general trend is actually the opposite. There are still significant barriers to naturalization in many countries, including prohibitively high fees in Austria and the UK. There's lengthy residence requirements, for example, in Croatia, Cyprus, Hungary, and Spain, inflexible documentation requirements, and also criteria related with good character or national interest in many countries. But change in this area is something that could be done quickly, easily, and would really dramatically reduce statelessness in a migratory context. So we're looking forward to see more initiative on this. The other crucial aspect to reduction is how states are progressing towards reducing their in situ stateless populations by implementing measures to identify and eliminate discriminatory laws, policies, and practices that perpetuate intergenerational risk of statelessness and which mostly affect minoritized and marginalized populations. As a follow-up from the 2019 Poznan Declaration, we have seen several Western countries committed to ensuring universal birth registration and to ending Roma statelessness, and they have been taking steps in that direction, which is really good to see. However, progress is still slow, and we're not addressing discrimination as a root cause, which is really causing issues with poor implementation. In 2022, North Macedonia has introduced the new law enabling people at risk of statelessness without personal documentation to apply for a special registration, but there are still some gaps in its accessibility and implementation that have been reported in practice, although we're hopeful to see that the government is holding consultations to improve this as well. And finally, but with an important impact across the boards, is that I want to highlight how stateless how the population data is one of the most problematic areas in the index, and stateless people are quite invisible in the data. And this is preventing states from accurately mapping the stateless population in their country, to review policies, to prevent discrimination, but also to find sustainable solutions to either resolve the nationality status of in situ stateless populations or to grant them the protection they are due under the 1954 Convention if they would not otherwise be able to return to their country of habitual residence. So several index countries actually held population census over the last couple of years, but there are concerns about the methodology used and the reliability of data. The census have not always included a category on stateless. And for example, in Czech Republic, the previous census in 2001 had collected that information, but the census in 2021 no longer included the category no citizenship. So lack of identification of statelessness is really an issue, and we're looking forward to seeing countries improving this going forwards, because another issue that it raises is the risk of increased unlawful and arbitrary detention, as is evidenced by more detailed analysis that we have also published in the index this year, including, for example, the lack of safeguards to assess whether statelessness is a vulnerability and relevant in decisions to detain a person for the purposes of removal, or safeguards to ensure that a country of removal is identified prior to detaining someone. So identifying statelessness is really a crucial step to prevent arbitrary detention, especially in the refugee context. And for more on this, we also have more resources available at our Stateless Journeys campaign that I'm sure colleagues can also share in the chat. So our analysis shows that urgent action is needed essentially in 5 key areas: introducing stateless determination procedures that are fair, accessible, and that lead to dedicated protection, also strengthening safeguards to prevent childhood statelessness, addressing discrimination as a root cause of statelessness, and then improving identification of statelessness, both in data collection systems, mapping studies, and in the context of asylum and detention. This is our general state of play assessment, but also with some positive notes to think about going forwards. And what I want to do now is really invite our panel of experts to hear from them on their reflection, their responses, and their recommendations on ways forward. And first up, we have Catherine Cosgrave, who is our country expert in Ireland. And she's also a specialized migration and human rights lawyer, the managing solicitor of the Immigration Council of Ireland. And I hope that Catherine can now turn on the camera and say hi. I don't see you yet, Catherine, but Hopefully I can hear you.
Yeah, it says I can't start the video because the host has stopped it. So if there's somebody at the back end there who can turn the camera on. Okay, now that seems to be working. So good morning, everybody. It's nice to be here, albeit still on a webinar, and I hope you're all very well. Thanks very much to the ENS for, first of all, involving us in the Stateless Index project itself for the last number of years, and also for the opportunity to speak to you all this morning. It's very nice to see you all joining from around Europe and further afield. My name, as Patricia said, is Catherine Cosgrave. I'm the Managing Solicitor at the Immigrant Council of Ireland. Apologies, just while I bend over for 1 second, my laptop became disconnected, so I just want to make sure it's plugged in. Sorry, so my name is Catherine, as I was saying. I work at the Immigrant Council of Ireland. It's an NGO based in Dublin, but we're also an independent law centre and providing free legal advice to migrants and their families in Ireland. And within the law centre casework, we have a particular focus on vulnerability, which would include individuals who experience statelessness, and that's one of the focuses of my work. So we're very happy to participate with ENS as members and to contribute to the development of the index and the Ireland country profile. In the time that I have available this morning, I'm just going to give a very kind of short overview of some of the positives within Ireland, address a number of key challenges, look at very briefly a number of contemporary issues, and then conclude with a focus on just some opportunities that might arise, particularly in the national context, for addressing some of the issues. So starting with a positive, I suppose, Ireland is a signatory to the relevant international conventions to address statelessness, and that results in at least some awareness on the part of both policymakers and the legislature regarding the existence of statelessness as a concept, as well as providing for some protections in Irish legislation, at least on paper, and I will come back to that in just a moment. And I suppose another positive is that there is really very limited use of immigration-related detention in Ireland. So as a general matter, where we look at reports that come out of ENS and elsewhere regarding like some of the issues that are experienced by stateless persons across Europe and further afield, at least in Ireland, as a general matter, there's very limited use of immigration detention for any migrants, but it's not an issue that tends to emerge from Irish research that stateless persons are routinely subject to detention or arbitrary detention. However, in terms of the key challenges that do exist in Ireland, despite some of the protections that we do have in Irish law, I suppose just to highlight some of those key protections, there is provision in Irish law for access to nationality for children born within the territory, and certain conditions need to be fulfilled in order for a child to have access to birthright citizenship automatically. They include criteria that one parent is either an Irish citizen or that one parent fulfills certain reckonable residence criteria, which is a period of lawful residence in Ireland for 3 years prior to the birth of the child. But where those conditions are not met, there is a saver that a child who would not meet those criteria will otherwise be entitled to access Irish nationality as a birthright if they would otherwise be stateless. So that is a positive. There is a saver there. And additionally then for adults or foreign-born adults, they may have access to naturalisation over time, and there's specific provision in Irish law that a stateless person may apply for Irish citizenship on fulfilment of 3 years residence in Ireland, and where they may access it on that basis, there is a fee waiver. Otherwise, it's €950 to be issued with a certificate of naturalisation. So there are some positives there, as I say, but the key challenge really for any person who may find that they are stateless is that there is in fact no stateless determination procedure. And this becomes the biggest challenge really for an individual to deal with. So how do they actually avail of the protections that are provided for within legislation, where there is in practice no easy way to have the fact of their statelessness determined? How it happens on a day-to-day basis is usually by engaging a lawyer, and it can take anything from years to many years for these issues to actually get resolved ultimately. And each case is dealt with, as I would describe in the country profile, on an ad hoc case-by-case basis, depending on what is the immediate issue that might present for the individual, whether that is in terms of actually gaining a residence permission in the first place, whether it is applying for an Irish travel document if they hold no passport, and whether or not it is ultimately they have managed to secure a residence permission on some basis, but issues relating to nationality and identity remain unresolved, and they have on paper the 3 or the 5 years required residence period to apply for citizenship, but need to address the thorny issue of identity, or more particularly lack of identity and statelessness in the naturalisation procedures. So the cases can be very varied, and they're inevitably quite complex to deal with. They take a long time, and my personal experience is that we eventually get there in the end for our individual clients, including where we issue litigation, but the litigation settles and the point remains unresolved in the long term. A second key challenge then is the very limited data regarding the actual level of stateless population in Ireland. There is extremely limited data from any source, including the Irish census results. And so this can make it a relatively niche issue to deal with, because it's not an issue that is clearly affecting hundreds of thousands of people in Ireland, and therefore getting it on the political agenda can be quite difficult in terms of advocating that this is affecting a huge number of people and that it needs to be addressed. In terms of contemporary issues, Patricia has mentioned in her opening remarks just a couple of things that I'll reflect on. So first of all, just to note in Ireland, our response to the invasion of Ukraine last year, in terms of a very general response, I suppose everybody in Ireland would agree that the government was proactive and has responded very positively, not just in response of how it has implemented temporary protection in Ireland, but in general. So we would have been an outlier in Europe prior to the invasion in that we hadn't lifted visa requirements for nationals of Ukraine, unlike other EU member states participating in Schengen. But the day of the invasion, Ireland lifted visa requirements on a voluntary basis and gave a very strong indication to carriers that anybody wishing to come to Ireland from Ukraine could do so, and minimal documentation was required in order to give effect to that. So ideally, obviously, individuals would have had identity documents, but if they didn't, they were allowing something, for example, like a Ukrainian birth certificate to be the short-term evidence of identity. And there were large numbers of people able to travel to Ireland in that context. And currently we have approximately 80,000 Ukrainians who have been given temporary protection in Ireland. I'm only mentioning it in the context really of the fact that this is obviously a contemporary issue for all member states at the moment. Issues relating to statelessness have not yet per se emerged. So whenever ENS has contacted us for an update in this regard, issues are not presenting into our service relating to statelessness yet, nor do they appear to be presenting to colleagues within other organisations such as UNHCR, Ireland Office, or the Irish Refugee Council. But I'm noting it as a possible potential because going forward, obviously, things may become a little bit more tricky, where the initial response to allow entry will become possibly a long-term issue that might need to be resolved, where individuals don't actually have identity documents, or identity documents may expire. And there are already some queries coming in regarding the different types of identity documents that appear to be issued by the Ukrainian authorities regarding internal identity documents and external identity documents, and getting them renewed. etc., etc. So I would just say watch this space really in terms of the issues that might actually emerge in the coming years. But to date, statelessness has not been a prevalent issue that has been presenting to services. The second contemporary issue I would note in Ireland is that in January 2022, the Department of Justice introduced what was called a long-term regularisation scheme, which was an opportunity for long-stay irregular migrants to apply to regularise their immigration status in Ireland. And it was a fundamental requirement under that scheme that an applicant would be able to provide identity documents to satisfy the Department of Justice regarding their identity. That's probably not hugely surprising. And it would appear that so far a relatively generous approach has been taken to evidencing identity on the part of an applicant. It was recognised in bringing forward that scheme by the Department of Justice that some individuals may have had identity documents that had expired, and that they wouldn't be able to engage easily with a consulate, either because there was no service in Ireland directly, or because consulate services in neighbouring EU jurisdictions may still be experiencing backlogs arising from pandemic closures and what have you. So a relatively generous approach was taken to this. And just by way of example, one of my clients applied, and the only identity document that she has held was a national passport that was issued to her when she was an infant. She's now in her mid-20s and has no document other than a passport that expired when she was a very small child, and the paper or the photograph clearly related to when she was 3 months old. And so there was possibly, you know, a question mark about this and whether or not indeed going forward an embassy will be able to renew it or what have you. But it's just, she has been approved under the scheme and allowed to register for a residence permit, but it will be subject to ongoing requirement to update that document and get a new passport. And of course, questions might arise in the years that follow from the grant of initial residence, whether or not some individuals will be able to do that. And if they're unable to do that, how those issues will be resolved going forward. Because outside of the failure to have a stateless determination procedure, we also don't really have any procedures in Ireland for establishing someone's identity or nationality where perhaps they're not stateless, but there is a difficulty regarding identity documents. So that's just to note an issue that might arise. But certainly there hasn't been, to my knowledge, anybody who has applied under the scheme who has been unable to deal with it to date, nor have they been refused on, for example, grounds of failure to provide any identity documents, and that there's possibly a question relating to statelessness. And then the third contemporary issue relates to...
Sorry, Catherine, just to say, if you could just try and wrap up, please. Soon.
Sure, of course, yeah.
It's really interesting to hear that.
I was just literally coming to the final points there. So the backdrop there is just to note then that despite these key challenges or contemporary issues, there are some opportunities to address issues relating to statelessness in Ireland. The first relates to the fact that I've mentioned already, litigation. In recent years, there have been a range of different litigation, both at domestic and regional level, relating to various different things, including access to nationality and assisted reproduction cases. And although it's not a case that has been referred from Ireland to the CJEU, the child at the centre of the baby Sophia case, for example, is potentially an Irish citizen. And there may be issues that go before the Irish courts in due course arising from similar types of cases. There's a case pending before our own Supreme Court, for example, relating to access to nationality and assisted reproduction cases. And there have also been some recent High Court and Supreme Court cases relating to deprivation of nationality, relating to how children have acquired nationality, where the child derived that nationality through their parents in some way, and where the parents have lost the resident status or the nationality that they had held. And the Supreme Court has held that the children cannot lose their nationality in that context, which is obviously very positive, but we don't know yet how the legislature may respond to these types of complex issues that are emerging. The second thing to note, just regarding the lack of data, the census results are due to be published. There was a census was done in 2022, and linking to that, we're expecting an updated UNHCR scoping paper any day now to be launched. And I think these will both provide useful insights and opportunities to advocate for reforms. Ireland also very significantly, I think, as a positive for us to note, appeared before the UNCRC in January of this year. And the UN committee gave very strong recommendations to Ireland regarding the need to address matters relating to children, citizenship and statelessness in Ireland, including stateless determination. And then very finally, I suppose, and most positively, is that the Department of Justice has recently indicated on a number of occasions that they are exploring and giving consideration to the introduction of a stateless determination procedure. And so that's really bringing us full circle, I think, from my key challenge to what is the major opportunity at the moment. So I'm happy to take any questions, and apologies for going over, Patricia. Thank you.
Thank you, Catherine. And it's really helpful to also hear how implementation in practice of all of these challenges that I mentioned in my presentation happens, but also understand some of these examples. And I'm glad that you mentioned a few court cases, because we have actually seen that lots of the progress that happened in the last 2 years was from the courts and less so from the government. So it's also really helpful to highlight some of those examples. So next up we have Dennis, who is our country expert on Germany. Dennis works as a legal consultant on statelessness and human rights with State Free, and he'll also be presenting his own expertise and experience on Germany. Thanks, Dennis.
Thank you very much, Patricia, and hello to everyone. I will just share my screen with you because I have prepared a little presentation. So I will be talking about statelessness in Germany, developments and challenges, and also upcoming opportunities. I'm currently working as a legal consultant for State Free, which is a stateless-led NGO in Germany, and also the only NGO that is focusing on the work on stateless advocacy. So maybe just a few brief words on Germany. There is no formalized process to determine statelessness, and it is most likely checked by foreign authorities, for instance, during procedures concerning residence status. But in all cases, officially at least, it is believed that the determination of statelessness can only happen when the person's identity is clarified in a final decision. And so there are some difficulties arising from this. And just because we were talking about the census in Ireland and Germany as well, there is a census going on right now on a national basis, and the results are expected to be published at the end in the end of this year. But there's recent figures, that show that as of the end of 2022, there were 29,455 persons registered as stateless, 25% of which are children or young persons below the age of 18. And that there's also 97,150 persons who were registered with unclear nationality. So maybe just to explain that this very large number of persons with unclear nationality, because determination of status requires the final clarification of a person's identity, if they lack official documents, this leads to a limbo where neither statelessness is determined, but the nationality status is not finally checked. So there are very long situations or prolonged situations where persons in Germany cannot access some kind of status or tighten or strengthen their nationality status or statelessness status. So between 2005 and 2013, numbers of stateless persons and numbers for persons registered with unclear nationality were stable. For stateless persons, it was up to 14,000 people, and for people with persons with unclear nationality, it was somehow 40,000 people. And since 2014, as you can see in the graph, there the numbers have more than doubled. And yes, they reached an all-time high in this year. So just a brief look, so you can see that only a proportion 5,000 people are born in Germany. The rest, 25,000 people, were born abroad. So maybe just a quick look on the other countries where the persons registered as stateless were born. Nearly 50% were born in Syria. Second is Germany with 16.5%. So 5,000 stateless persons were born in Germany. And on the third place, it's persons whose country of birth is unknown, and then followed by Lebanon, Israel, and the Russian Federation. So I will now talk very briefly about the recent developments in politics. We have a citizenship law in Germany that is on her way, a draft bill that will amend the nationality code, which is a very sensitive topic in Germany, but also priority of the coalition that is expected to bring forward, well, very progressive changes. And what is expected is that the minimum residence per requirement for naturalization will be shorter. It will go from 8 to 5 years. The principle of avoiding multiple nationality is also going to be deleted, and a safeguard is introduced to prevent loss of citizenship resulting in childhood statelessness. So, for example, if the paternity link is not if the paternity link is not established or questioned, then the child will not lose German citizenship, and in all other cases. So if, for example, the parents did acquire nationality on false grounds, or if they have lost the residence permit that they need, the child will not lose the German citizenship. And so maybe just to briefly talk about challenges, it is at all times a challenge in Germany to empower statements to fight for, or to work in this field of advocacy. And I will start with looking at the equal rights or empowerment through equal rights pillar. Then I will talk about the visibility of statelessness and in Germany, and also the stateless community and its allies. So first of all, when we talk about statelessness and the legal perspective, we have to bear in mind that statelessness did not play a role during the negotiations of the coalition agreement. So it was never directly addressed also in the bill, in the draft bill that should amend the nationality code. And it is an issue that was not agreed upon. So if policymakers consider to address statelessness, it is a challenge to introduce these new issues and also to convince the others. So just for a quick parallel or an example, when the coalition agreement for the Lower Saxony, so Germany is divided in 16 federal states, the coalition agreement in Lower Saxony specifically states that the acquisition of citizenship shall be facilitated for refugees and stateless persons. So there is also something well, we see that there is the basis for advocacy that is coming up, in this federal state, for example. But for opportunities, so our opportunities are what we as Statefree wish to address with regards to the nationality code, is that the visibility of statuses in the nationality code should be strengthened. So, for example, the legislation allowing to acquire citizenship for stateless children that are born in Germany is not located in the nationality code, so it remains invisible and largely unapplied. But also because of the federal system in Germany, and because all federal states have their own foreigner authorities and nationality authorities, well, the understanding of statelessness is not the same everywhere, and this also leads to differences in understanding and treatment of statelessness, depending on the interpretation of the code. And and then for facilitation of naturalization for stateless people, what remains a big challenge is that, well, there's further necessities or legislative provisions need to support authorities that are confronted with statelessness, because there are possibilities when it comes to recognize a person's identity or statelessness to, for example, take into account proof that is not only official documents, or to not take official documents into account. And to exhaust all other possibilities to prove and to establish a person's identity and statelessness, there's more clarification needed. And so we hope that if this would be clarified, then the authorities would be able to apply the code with respect to stateless persons. So, and the last thing, what is a challenge is, of course, the expedition of the naturalization procedure. So this is not codified, neither for stateless persons nor for refugees, and still it must be ensured that the right under Article 32 of the 1954 Convention is not neglected. And last but not least, stateless children's birthright to acquire the German nationality right now is not in conform with the 1961 Convention. So right now it is a requirement that children need to have 5 years of legal residence before acquiring German citizenship. And this is, of course, against the best interest of the child. So we want to delete this legal residence requirement, and this is, of course, a challenge. But there are other challenges when it comes, for example, to the visibility of statelessness. There's very little awareness and knowledge of statelessness. We had an instance where a minister talked about the deportation of a stateless Palestinian. So there is some kind of misunderstandings, I think, in the concept of what is statelessness on the understanding. And State Free is working in this regard with, for example, an exhibition that was launched last year, but also a podcast that was launched last week that we invite to listen to, because it is very important that people can, in fact, connect and form a community or work together as allies. And this is another challenge in Germany. And just a quick look at what is coming up now is that with view to the nationality code, there's this very clear goal of engaging with members of parliament, with politicians. And it's very important to also work with other organizations in Germany so that, our advocacy can be echoed, and that it is taken into account when preparing or when commenting on the draft bill. And also State Free is also preparing a comment on the draft bill. So we will look into this from now on. And maybe a last thing is to create a strong narrative and convince politicians to address statelessness in the context of the nationality code, or also in upcoming legislative procedures, because even if it was not foreseen from the beginning, but there is a necessity, and there is also a strong opportunity, not only in the context of the nationality law, but also when we look up at upcoming legislative projects, for example, the next migration package that is also expected and to have a positive impact and should also be progressive. So there is kind of the need to create an impact to pressure politicians to take into account statelessness, and for that visibility in the media is very important. Thank you very much, and sorry for going over the time, but back to you, Patricia.
Thank you very much, Dennis, and we're really looking forward to hear more about the upcoming law reform, so we'll stay tuned for that as well. Next up, as we are running a bit behind time, is Valérie Klein, who is the country expert on Belgium. And Valérie has been working as a legal officer for Nansen, who is our partner in Belgium. She specializes in matters related with asylum and detention. It is also the reference person on statelessness within Nansen. Valérie, on to you.
Thank you, Patricia. Good morning, everyone, and thank you for the opportunity to speak today. It's always a pleasure to take part in an event organized by ENS. There are two recent developments in Belgium that I would like to discuss today. First of all, a very recent legislative proposal on the right of residence of stateless persons. And second, an amendment to the Belgian Nationality Code concerning stateless children born on the Belgian territory. First, so this new legislative proposal regarding a residence permit for stateless persons. Just a quick word about the current situation for those who don't know the Belgian context. In Belgium, the judiciary is competent to determine statelessness. But as Patricia mentioned it earlier, recognition as stateless does not result in an automatic right of residence, which means that an application must then be made to the immigration office for regularization on humanitarian grounds. But the law does not lay down criteria, which results in a wide margin of appreciation for the administration. In 2020, the new government put the issue of the residence permits for stateless persons on the agenda, and very recently, a proposal was, a legislative proposal was drafted. It has not yet been published, and it can still be amended, but I can give you an overview of what's being decided. So the proposal creates a new procedure to obtain a residence permit as a stateless person. It's a procedure parallel to the court procedure I just mentioned, but it will not be required to be recognized as a stateless person by the court to obtain a residence permit as a stateless person. But if a person is already recognized as stateless by the court, the administration may take this into account. However, the administration, according to the proposal, will be able to deviate from the court decision if there are indications that a person is not or no longer stateless. So I will not go into details into the proposals, but just to highlight a few positive elements according to Nansen. So the law will now lay down criteria which will limit the discretionary power of the administration, which is a very big problem at the moment. Secondly, what's also positive is that if a residence permit is granted, it will have a duration of 5 years, initial duration of 5 years, and then be for an unlimited duration, as opposed to 1 year now and renewable under certain conditions. So that's a certain that's an improvement. And family reunification for beneficiaries of this residence permit as a stateless person will be under the same conditions as for beneficiaries of international protection. So that's also something that is positive according to Nansen. However, we believe that this procedure is highly complicated, and with Nansen, we have serious doubts as to whether it will actually improve the situation of stateless persons in Belgium as far as residence permit is concerned. There are many reasons why we think there are problems, but I will only name 3. First, we believe that the possibility for the administration to deviate from a court decision is very problematic with respect to the rule of law. We also noticed that there is an admissibility phase, which could mean that certain persons will be denied access to the procedure. And thirdly, we believe that the substantive criteria to be authorized to stay in Belgium on the basis of this new procedure go beyond the criteria laid down by the Belgian Constitutional Court, a few in different rulings, and also that some of those criteria are not in line with the 1954 Convention and the UNHCR Handbook. This is certainly something that we will follow up and comment at some point once the law is officially published, and hopefully also together with ENS. A few words now also about the amendment of the Nationality Act. This was already published in December, and it concerns stateless children born on the Belgian territory. So according to the Belgian nationality law, a child born in Belgium will be Belgian if they would otherwise not have any other nationality. This is an article of the law that has been used a lot by parents of children of Palestinian origin born in Belgium, also by other people of other origins, but a lot by Palestinians. But there is currently a lot of discussion in Belgium concerning statelessness of Palestinians. And Belgium being a complicated country, the views also differ from one linguistic region to the other. And from now on, with these new amendments, if the civil register has a doubt about the statelessness of a child, then he or she will have to seek the advice of the King's prosecutor. This could be positive because it could harmonize the practice, because at the moment, depending on the municipality where the child lives, lives, he or she will not be considered stateless. So there is a kind of municipality shopping because people know where the practice is positive. But on the other hand, we also noticed that quite a few prosecutors consider Palestinians not to be stateless, and in so they are influenced by a position of the general prosecutor, which means that backed with these amendments, bad practice could actually spread as a result of these amendments. But only time will tell what this amendment will mean in practice, and this is also something that we will follow up on together with ENS. And just lastly, a few words about the use of the index in Belgium. The first time it was published, we received a very interesting feedback from the person in charge of the statistics within the immigration office. And we have kept in touch so far, so that's been very positive. And it has enabled us to present proper statistics in the index and also to interpret those statistics correctly. We also refer many people who come to us for information, so students or academics, but also journalists to the index. It's nice for us because for a workload, but it's also very useful for them because it gives them access to quality information and this very quickly. And we were also contacted by a journalist who wanted to write a piece about statelessness in Belgium, and he very much used the index. The only thing that is unclear to us at this point is how immigration lawyers use the index in their daily practice, but that's a point that we are certainly working on. Voilà, thank you very much. That will be all.
Thank you very much, Valérie. And again, thank you so much for bringing some of the insights on the practice and the exciting upcoming developments that will hopefully lead to better protection of stateless people. But we will stay in touch on that to make sure that we can introduce positive amendments in the law as well. I'm sorry to the participants, but we are running a little bit over time. Hopefully that is because this discussion is being really rich and you can all see the value in continuing this. Our last speaker is Chris Nash, who is the director of ENS, and we're looking forward to hear from him on some of the results on the trends in Europe as well. Thanks, Chris.
Thanks, Patricia. And my internet connection's a bit stable, so please do you or Jan give me a shout if it gets too bad and I can switch my camera off. Good morning, everyone. And I would like to start by commending the great work done by Patricia and the ENS team on the index, as well as our members and index country partners across Europe. It's a huge labor of love, sweat and tears, but it's really important in underpinning our work as a network. It's also hugely impressive that since launching the index back in 2018, we've been able to expand it to now cover 30 countries and to have had almost 50,000 unique users. As Patricia outlined in her presentation, our analysis shows that urgent action is needed in 5 key areas. So it's perhaps helpful to start by recapping what these areas are. So firstly, we want to see the introduction of stateless determination procedures that are fair, accessible, and lead to dedicated protection. Secondly, we want to see strengthened safeguards to prevent childhood statelessness. And thirdly, we want to see the addressing of discrimination as a root cause of statelessness. And fourthly, we want to see improved identification of statelessness in data collection systems, including in the context of asylum and detention. And many of you yourselves will recognize the urgent need for action in some or all of these areas in your own country. And it's also undeniable that in some respects, our index analysis, as skillfully presented by Patricia earlier, does reveal a relatively negative picture. And it's obviously important that we acknowledge some of these negative trends and lack of protests compared to where we would ideally like to be. But at the same time, I think we should recognize, and I'd maybe like to stress this as my first point, that it's actually a good thing that we have the index, precisely so that we can understand what gaps still urgently need to be addressed. And 5 years ago, we simply did not have a tool like the index to help us do this. And as a result, back then, many problems and gaps were left under the radar, forgotten and unaddressed. Because if you can't see a problem, you can't fix it. And this is why the index is so critical to support our change efforts. The index not only supports our conventional awareness raising and advocacy in partnership with our members across Europe, it also provides an evidence base for our human rights advocacy, including joint submissions we regularly make with members towards the UPR, the CRC, and other UN treaty bodies. It also supports our strategic litigation, as we recognise that part of the change to end statelessness must happen through the courts. And my second point would be that despite the relative lack of progress, there is also cause for optimism in several countries, including some ongoing discussions to introduce legislative reforms that could better help protect stateless people. We heard about some of these earlier, but also in Albania, for example, a country that made several pledges at the last Global Refugee Forum, we've seen reform to their birth registration process and a commitment to introduce an SDP. Valerie was talking earlier about some of the ongoing discussions in Belgium, and Catherine about those happening in Ireland, and Dennis in Germany. But in addition, I was in Malta a couple of weeks meeting with their Ministry of Interior as Malta pledged to introduce a stateless determination procedure back in 2019. It's yet to happen, but hopefully it soon will. Likewise, the Netherlands, there's reforms which are happening and underway. And we're hearing positive noises from Portugal that they might soon introduce an SDP, as well as Switzerland. And all these welcome reform processes provide an opportunity for governments to live up to their commitments, to hear the voices of stateless people and find solutions that respect and fulfill human rights. So we hope that the index, by shining a spotlight on gaps in law, policy and practice, can help inspire new changes in other countries. And this brings me to my third and final point, and indeed a key purpose of today's webinar, which is our hope to engage and encourage more stakeholders to use the index. And in this regard, I noticed, and it was really welcome to see the poll results at the start of the webinar showing that 41% of participants today were joining to learn more about the index. That's really welcome, as it suggests that many more people want to get involved with our change efforts. And I will end by quickly flagging another such opportunity to get involved with our change efforts. That is that on the 8th and 9th of June, we will be holding a major regional conference on statelessness in Madrid. This is intended to raise awareness, to forge new alliances, and to help galvanise much needed reforms to better protect stateless people and ensure everyone's right to a nationality. A key objective for us is to connect civil society and stateless communities with regional and national policymakers in order to achieve transformative change. And in this regard, we're really excited and delighted to have several high-level speakers. For example, Michael O'Flaherty, the director of the EU Fundamental Agency for Fundamental Rights, Nina Gregory, the executive director of the EU Asylum Agency, Gillian Triggs, the Assistant High Commissioner for the UNHCR, Leila Kajasic, the Council of Europe Special Representative on Refugees and Migrations, and others, keynote speakers who will really help us to put stateless people and civil society in a space with those policymakers to try and encourage change and get the issue higher up their institutional priorities. The conference will also be a big milestone for our Stateless Journeys campaign, which seeks to sensitize refugee response actors to the particular protection needs of stateless people. And at the same time, we will be using the conference to further examine and address the link between statelessness and other nexus areas, such as child rights and anti-discrimination. So do come and join us in Madrid. And I think the registration details are in the chat box. And I'd just like to finish by reiterating huge congratulations to Patricia, the whole ENS team, as well as the speakers today for all the work on the index. It really is making a massive change and contribution to our change efforts. So congratulations, everyone, and thank you.
Thank you very much, Chris. And thank you to all of the panelists and speakers today. It really is a pleasure to have you here, and a big applause to all the tireless commitment to addressing the issues that we talked about today, to the panelists here, but also to all of the other index country experts and ENS members working on this. We have seen lots of questions and engagement in the chat, but just a reminder that this is not the end of this conversation. So do stay engaged and get involved in our work. As Chris has said, we're excited to see that more people are using the index and interested to hear more about it. So our contact details are on the chat, and we're really looking forward to continuing this conversation. We encourage all of you to access and share the index as an online tool for regional and country level audiences, but also please send us any comments, any feedback you may have on it, and tell us more about how you have been using the index in your work, as Valerie has just given us some examples. Also keep an eye out for more translations of the country profiles in the index going forward. And otherwise, we're really looking forward to staying in touch. Thank you everyone who joined today's. Bye.